At IBCanada Group, we are your complete and independent source on the infinite banking concept, serving Canadians from coast to coast.
In Canada, when you die, for taxes purposes, you are deemed to have disposed of all of your property immediately before your death at fair market value. For non-registered assets like mutual funds, segregated funds, and even real estate. If the fair market value is greater than the amount that you originally paid for them, you could trigger a capital gain. In addition, the full value of your RRSPs and RIFs at death are also brought into income. There are a couple of exceptions, for example, the principal resident exemption or if you roll over assets to your spouse. But otherwise, taxes at death can generate a huge liability for your estate and your beneficiaries. In addition to taxes, there's also something called estate administration tax, more commonly known as probate fees, which are a type of tax levied provincially on accumulated assets at death. There is a significant amount of confusion regarding the difference between income tax as opposed to probate fees. My name is Chow Ivanovic, member of the IBCanada Group. What exactly happens when a will is probated? At a very high level, probate is simply the process of confirming the validity of a will. So when someone passes away, presumably there is a will. Presumably there is an executor. That executor takes that will to the court in the jurisdiction where the deceased had passed away to be probated. And the probate process takes approximately 1 to 3 months. At times, even longer if there are challenges to the will. Keep in mind that it is a time-consuming process. So when the executor brings that will to the court, probate process does not happen that day or overnight. It takes a while. The longer probate process takes, the more issue at the estate level can arise. For example, liquidity issue. Estate can be assets rich but cash poor. Eventually, when the will is probated, the certificate of appointment is issued by the court. Basically, probate confirms the validity of the will and confirms the executor. And at that point of time, the executor has the legal authority to start the estate wrap-up and distribution process. Handling of the estate can still take a long time, depending on the complexity of the estate. The probate really is the first step at the end of the day. How much are the probate fee? Obviously, nothing is free in this country, including getting the will probated. The fees vary depending on the province where you live and hold assets. For example, the probate fee in Ontario is 1.5% of the fair market value of the assets of the estate. Also, keep in mind, probate is levied provincially. In Ontario, for example, it is governed by Ministry of Finance. Nothing to do with the federal government, nothing to do with the CRA. Every province has its own probate process as well as probate fees. Ontario has one of the higher rates and is more complex from an administration standpoint. You might say 1.5%, that's not that much. Why plan for such a small amount? If you have a $500,000 estate in terms of value of the estate assets, $7,000 probate fee is not a material number. But if you look at the larger estate, like $5 million, which is not that unreasonable, especially given real estate values in certain areas of the country, you can be on the hook for $75,000 probate fees. All of a sudden, it becomes a lot more material. Also, probate is separate from income tax. When someone passes away, say they are at the highest marginal tax bracket for income tax purposes, which in Ontario is 53.53%. That means the estate is responsible for taxes at almost 54%. With tax of an additional 1.5% in terms of probate, you are now looking at an effective tax rate of 55%. When you get into the high marginal tax rate, high net worth situation, why not plan for the probate avoidance? You really want to try to maximize the estate and try to maximize the assets you will be transferring from generation to generation. So 1.5% on its own might look small, but dealing with a high marginal tax rate and at the same time dealing with a large estate can become punitive. Who can request probate? Any interested party may request probate to confirm the validity of the will. Basically, it boils down to financial institutions, perhaps charity named as beneficiary under a will. Executors may want to get the will probated for their own purposes to protect against potential liability in the future. Financial institutions really are the key players. They have a certain probate threshold in terms of account value. Think of bank accounts, mutual funds investments, stock portfolios, etc. Usually, the cutoff is around $100,000. For account value over and above that threshold, financial institution in question will not release estate funds to the executor in the absence of a probated will. Be aware that in Ontario, there is a requirement for the executor to file an estate information return within 180 days after estate certificates was issued. This return must include a detailed listing of everything that flowed to the estate and a complete breakdown of the fair market value of the estate. This is an additional layer of complexity to settle an estate in Ontario. And this is something virtually unknown to most people who haven't been an executor in the past 6 years. Does every will in Canada have to go through probate? Not every will needs to be probated. If it happens, the deceased structured the affairs in such a way that they didn't have assets flowing through the estate. For example, they passed away with no real estate because it was sold. There is a good chance that will won't need to be probated. Or when the entire estate is held jointly and the assets are passing to the joint asset holder, like husbands and wives holding 1 or 2 joint bank accounts and a jointly owned house. If the first partner died and left the entire estate to the surviving partner, then probate can be avoided. It is also important to point out choosing not to write a will is not a strategy for avoiding probate. If you die without a will, you are deemed to have died intestate. You are still subject to the probate process, and probate fee will be incurred either way. You can watch my previous video about dying without a will for more information on that topic. I hope you find this information valuable. Until next time, thank you for watching.
IBCanada Group, your independent authority for information on the infinite banking concept.